teach young law students how to try a case. I went on to the U.S. Attorney's Office where, well, while I was in the State's Attorney's Office, I probably tried a dozen plus felony juries, hundreds of bench trials, and then I went on to the U.S. Attorney's Office where I tried more cases, more juries, argued in the Seventh Circuit, and just from prosecutorial experience, you know, it's not all about prosecutorial experience, because obviously we have somebody there who's been there for 29 years, and I don't think her record is very good, and I wouldn't want to have to stand on her record. But my concern is that, you know, when we got information from the State's Attorney's Office, you know, Ms. Fox didn't go through the whole office. She was never in the felony trial division. 11 of her 12 years were spent in juvenile, and according to Anita Alvarez's records, she tried one case in juvenile, a possession of controlled substance case, which would have been a bench trial. And if that's not right, you better correct it, because this is based on FOIA.
Yeah.
You got to do it, because she tried. That's what the record says.
Donna, but you know, I mean,
I'm just telling you what the record is.
But I'm saying, for an office, and I've said this before to you privately, and I will say it publicly, for the office that's the State's Attorney's Office, which is the office that should be held to the highest standard of integrity, that you know better than most that it is impossible to go through the State's Attorney's Office having tried one case. I looked at the federal record, and it didn't have you listed. But I believe you when you say, but it didn't have you listed. But I don't go around telling people that you never tried a federal trial, because a document that may not be accurate says that. You know for a fact it is impossible to have been promoted to a supervisor, unless you are suggesting otherwise, to have never tried but a possession of a controlled substance case in order to be promoted.
They said you tried one possession of controlled substance case and one
double jury. Double jury.
Yeah. And they gave the records, they gave your trial sheets.
We didn't do trial sheets
your double jury. All I'm saying, Kim, is it is hook, line, and sinker. It is a 3-page document, and you should correct it. So all I'm saying is you were never in the felony trial division.
Then say that.
Okay,
you are running to be the State's Attorney of Cook County.
Yes.
You are running to be, as we talk about convictions at any cost, if we're talking about winning at any cost, part of that is let's not distort facts for your purposes.
I agree with you, but when I read your bio that says you prosecuted or supervised thousands of cases, and you only prosecuted, according to Anita's records, 2 cases, I gotta ask, who's misrepresenting what? So anyway, my point is you were never in the felony trial division. You were in felony review based on her records for about 2 weeks, and you don't have the experience to lead that office and to make the tough calls, because you were never in the felony trial court staff to make those tough calls. You never investigated and led a trial team. Your double jury, it says you were a second chair. So all I'm saying, I just said your double jury. You told me it was a double jury, so I'm using your stuff.
You're correct in that.
So all I'm saying is something is amiss with qualification, and we need to figure it out, because what I see in qualifications is that something is wrong between what is over here and what is over there. So yes, I understand you weren't in the felony trial division. I would suggest, because this is what I'm getting based on a FOIA request, that you need to correct that if that's not an accurate record out of Ms. Alvarez's office.
If I may. This is a very important office. This is a conversation that I've had with Ms. Moore, and I want for you all and the public to know. Ms. Moore talks about her experience in the office. I'm not going to negate anything that she says that she's done, even though I can't verify it based on the information she gave. She said it, I'll take it. Her experience as a prosecutor was really. What I find most compelling about this entire conversation about misconduct, when we talk about all of this, and Ms. Moore's insistence that it was in the last 8 years, and not that she was in the office, and that she talked about that she was a supervisor in the 80s, in the height of the Burge era. When questioned about it, she said previously, oh, I was in a different unit, it wouldn't work. Felony review is dead smack on that. Take nothing away. Her work in prosecution, her work in criminal justice was not in this century. Where we were on criminal justice issues in 1984 to 1989 is not where we are now. We are unraveling the road that we've been on for policies from the 80s right now. My record. I started as an assistant public guardian representing children in our foster care system beginning in 1998, and I did that work until 2001. In 2001, I came to the state's attorney's office, as Ms. Morris said, not because I was related or connected to anybody. I came as a lateral, having spent 3 years out of plea practice, and was hired to do child protection work in the unit that they had just formed called the Family Law Track. In the Family Law Track, we prosecuted cases, or we tried cases, and it's a civil division, of child abuse and neglect, everything from heinous sexual abuse to abuse of head trauma, shaken baby syndrome, and the like. I became an expert in trying those cases and stayed in that work for about 4 years because of the social nature of the work. I then went to become an assistant state's attorney in our delinquency division. What Ms. Moore knows, or perhaps does not recall, from her time in the office in the 80s, is that you must try cases in order to move up through the ranks. You start off as a third chair, you move to a second chair, then you go to a third chair. And in order to move up, you have to try cases. So we tried everything from, as she noted, PCS, which is possession of a controlled substance, which is a class 4 felony, which is the least among them. In our criminal justice system, and no different in our juvenile justice system, we do a lot of drug cases. Lots of drug cases, because we have drug issues here. And so the notion that I would only have done one drug case in a county that does many drug cases is erroneous. I did everything from possession of a controlled substance to first-degree murder. First-degree murder. And everything in between. I moved up from a third chair to a second chair fairly quickly and became a first chair within 5 months of having been in the delinquency division. While in the delinquency division, I went to training at the National College of District Attorneys in South Carolina, which is like trial ad training for young prosecutors throughout the country. Having completed that training, I was invited back without having applied to teach at that institution. I was the first person in the history of the Cook County State's Attorney's Office to be invited to teach on the national level, having only been in the office at that point for 6 years. I taught at the National College of District Attorneys trial advocacy to attorneys from across the country. I left the delinquency division and I went to felony review. I was in felony review from I went to preliminary hearings, which is how I know about the number of drug cases that are thrown out at our preliminary hearing unit. I did that for about a month. I was in felony review for about 4 months. Then I went to sex crimes. I was in sex crimes for about 6 months. I was in sex crimes at the time of the R. Kelly trial with Sean Bolivar about Heisenberger, where the trial was assisting in the case. And I worked on the research team assisting him on that case. I went back to felony review for 2 weeks after I came back from sex crimes and was given the opportunity to have a promotion to be a supervisor in the juvenile delinquency division. At the time that I became a supervisor in the juvenile delinquency division, it was almost unprecedented because I'd only been an assistant state's attorney at that point for 7 years. I tell people when I applied to be an associate judge back in 2011, at which point we have to list all of the trials that we've done. And we also have to give the opposing counsel that we worked against and the judges who saw us do those trials. But it was almost as though my career was in dog years. Because in the 7 years that I started, I was a specialist doing child protection cases, moved my way into delinquency, became a lecturer to trial assistants from across the country, and then became a supervisor. And while as a supervisor, I had 4 courtrooms that had 3 attorneys in each courtroom. Those courtrooms were managed up to, and we had thousands of cases during that time. I continued to also do trials because I wanted to continue to maintain my skills. The double jury trial that Ms. Moore speaks of was a highly publicized case in which 2 women hired juveniles to douse a romantic rival with battery acid. A double jury, unlike a single jury, is when you impanel 2 juries at one time, and you have to have them moved out of the office or out of the jury box when you're presenting certain evidence. It is very complicated and very rare that we do double jury trials. I also was a supervisor on the case of Darian Albert, When we talk about what's happening with Michelle McDonald, you may recall that Darren Albert was murdered on video on his way home from school at the time that we were fighting to get the Olympics here back in 2009. That was a case that had 5 individuals, one of which was under the age of 15, prosecuted in juvenile court under my supervision. During the course of my 5 years as prosecuting supervisor in the State's Attorney's Office, again, I was the supervising attorney on and trial attorney on an additional 3 murder cases. I left the State's Attorney's Office and then came to work as I started this conversation at the President's Office. I was hired because we wanted to take on criminal justice reform for, as I mentioned, the $500 million we spent on our tax dollars there. When we talk about leadership and changing culture, we all know the history of Cook County and the patronage and the waste and fraud and abuse that had plagued Cook County for many years. President Preckwinkle came in and instituted performance management, where we had to sit down and look at data, metrics, best practices, so that we can align our policies and practices in what was in the best interest of the taxpayers. As the chief of staff to the 2nd largest county in the country, I was responsible for all offices under the president, which is about 4,500 employees, and a $4 billion budget. Everything from our chief financial officer, who deals with our day-to-day taxpayer dollars, to human resources, to technology. To suggest that somehow the experience that I've had working in those areas and actually getting things done, whether it was collective bargaining agreements, to which I sat at the table and negotiated collective bargaining agreements for 36 collective bargaining agents, and having done so well, that the labor unions in which I engaged in that collective bargaining have all endorsed me because of the work and my working relationship and ability to get things done. We do need leadership in this office. I defend my trial experience not because I believe that that's at the forefront of what that office does. Anita Alvarez has done more trials than Donna Moore and I 5 times over because she's been there. What she's failed to do was exercise leadership and to do it in a way in which the public can have trust and faith that our criminal justice system works for everybody. I'm not here to try to out-credential Anita Alvarez's trial or Ms. Moore's trial at all. I stand on the record that I have. But for point of clarification, because I didn't want to forget, I'm also published in the Illinois Institute of Continuing Legal Education for Juvenile Justice. I have spent the last 19 years of my career in some form or fashion working in public service for the citizens of Cook County because it is deeply personal to me. I tell my personal narrative wherever I go because it informs why I got into this work, which again is why it becomes incredibly insulting that somehow someone who's dedicated their career to this work, who had an incredible opportunity to make real change in our county, is somehow suspect because Ms. Moore has chosen to believe that I could not want this job because I was capable, competent, or qualified to do it and had a mission based on my career to want to give back to the county for which I live. That's why I'm running for this job. Not to be beholden to anyone other than the taxpayer, and to the citizens, and to the people who came from neighborhoods like mine who felt that the criminal justice system treated them differently. Last point. As it relates to state's attorneys, handling the big cases. I said this yesterday and I'll say it again. It's not the big cases that define what kind of state's attorney you are. I handle cases with 5-year-olds who were raped by 14-year-old boys in the back of the school locker room, and it broke my heart. We'll never know the name of that young boy or that defendant because they were juvenile. But every day I think about that young man who's probably about 9 years old right now and hoping that he's able to recover from the abuse that he's dealt with. That's why I'm doing this. That's why I dedicated my career to this work. Not to get on big cases. I got that. But to do the work for the people whose voices and names we'll never hear and know that here in Cook County they can get a fair shake.
Let me ask just one quick follow-up on that. Do you consider your relative lack of felony experience to be at all handicapped?
No, I mean, I consider only that I have to address it because my challengers seem to think it's an issue. And I have to be clear. I wasn't in the felony trial division. Not that I didn't do felonies. so that there's no confusion. The Illinois Criminal Code defines what a felony is, and there's a burden of proof for law, beyond a reasonable doubt. Whether you're 70 or 17 or 7, beyond a reasonable doubt is the statute. The difference between juvenile and adult is the sentence, not the proof, not the burden of proof, not how you get your evidence. None of that changes. None of it changes. So the ability to try cases, which is why I mentioned that I was brought on to the National College of District Attorneys because of my trial skills and the fact that I was a supervisor training. And so when we talk about the training that we give, the CLE training, I trained lawyers in the 5 years that I was a supervisor on everything from Fourth Amendment rights to search and seizure to the changes in juvenile court law. I've done it. It doesn't handicap me. What handicaps our system is incomplete conversations about what it's going to take for us to fix it. It's disingenuous notions that we can cure biases that impact decision makings on the day-to-day courtroom work that goes on that can be cured by one individual. It's knowing that what we need right now in this county in order to get us beyond where we are, which is truly a national embarrassment, is someone to step up and take a leadership role and say, because the state's attorney, whether it's me, Ms. Moore, or Anita, on day one, you're not going into a courtroom. What you need to be going is into the community and trying to reestablish trust from those who need us the most, who trust us the absolute least. But if I needed to go in the courtroom, I'm very confident that I would be able to do that.
A couple things. Look, we have a state's attorney right now that misrepresents things to the public that isn't transparent. I can only go on certain things because we can't get more information via FOIA for Anita Alvarez's office. I think the double jury is the only jury that you've tried.
That's not true.
There are no juries in juvenile court, and according to your record, there were no murder cases. I get it, Kim, but I just want to tell you what's out there. What worries me...
You're speaking as though it's true, though. That's the issue that I have.
Well, so then we have a bigger problem with Ms. Alvarez, because then her office is putting out total misstatements in regard to freedom of information requests. And that may be because, let's not forget, she's being sued over her FOIA responses by Better Government Association and by the CJP, Criminal Justice Project. So it may very well be, but I'm just putting that out there. My other concern is this. For Ms. Fox was in the office 12 years, Anita was there for 29 years. 5 of Ms. Fox's years were under Anita Alvarez's tenure as state's attorney. And as I understand it, the juvenile division was bad then, just like it's bad now. And one of the other things I asked for in my FOIA request was documents, memos, something on suggestions of how to reform the system. How do you reform juvenile? What are your suggestions to do so? And there weren't any. So my concern is that if you can't stand up to Anita Alvarez as head of the office to say, juvenile's broken, Ms. Alvarez, and here's what we got to do to fix it. How do you stand up to the mayor of the city of Chicago, the sheriff of Cook County, the president of Cook County? And again, you know, I mean, maybe I'm
just Attorney Daly.
Yeah, exactly.
You were there for 5 years during the Burge era. Did you stand up to State's Attorney Daly and say?
Excuse me, the Burge era. I mean, I am old, but the Burge era was before my time. I did not have a Burge case. I wasn't even aware of Burge when I was in the office because it really didn't come to light until after I had already left. But if I knew, listen, I was investigating a big financial crime issue for the mayor on construction fraud contracts, and I met with him every week and said, here are the subpoenas I'm issuing and here's why. And not once did he shut me down, and had he shut me down, I probably would have said, you know, adios, I'm out of here, because I'm not going to work in an office that doesn't want me to do the right thing. But in juvenile for 5 years, I view both of my opponents as part of the status quo because nothing got reformed. And again, if you're not going to stand up to Anita Alvarez, how are you going to stand up to anybody else in the county that's going to put pressure on you? And you know, when we talk about a passion to do this job, or politically how you came to run for this office. You know, the Sun-Times has reported in 2 different articles that, you know, Toni Preckwinkle was doing a poll on how Kim Foxx would play to the public in January of 2015. Ms. Foxx announced in August 2015. And Ms. Foxx initially, according to the Sun-Times article, I'm not saying it's wrong or right, says, well, I'm just saying what's out there, because I want answers. I want transparency in this office. And so Ms. Foxx initially, according to the reporter, said, I didn't know about the poll, and then emails were found where she in fact drafted poll questions. So this was, at a minimum, a joint decision by a powerful political leader, because without that power to twist arms, to get money, to run, it would have been almost impossible. Look, I don't have any political clout, and I can tell you it's very tough out there to get money and whatever. But if you have somebody behind you, if somebody gives you, direct or indirect, all the money in your campaign fund, and then they call you and say, really be great if this happened, what are you going to say? No. I mean, the Ms. Preckwinkle sat in the front row of her son's battery case, and a judge that she helped get on the bench tosses out the case. That's the Cook County way. That's what I'm fighting against. And it's a tough fight. And I take nothing away from Ms. Foxx's credentials. I think, look, she's a decade younger than I am. I would love to have her get felony trial experience, make her distance from President Preckwinkle and Joe Barrios, and you know, and do this. But right now, I have to say that both of my opponents to me represent status quo, and that to me is not politics. Politics is about change.
My last point, because it's not a debate, but it is. Ms. Moore just said that it's not about taking anything from my credentials. In all of the conversation that Ms. Moore has talked about her credentials, she fails to say that they stopped at 1991. She fails to mention the work that she's done in the last, like, today.
I'm happy to mention it.
But what I'm saying is, every conversation about credentials is a takeaway. I've run on this office, and I take nothing away. I'm really proud of the work that I did for President Preckwinkle. As I started this conversation, a lot of the significant changes that we've seen in criminal justice work didn't come from the state's attorney's office. They came at the push of the president's office. Around foreign court reform, juvenile justice reform, economic development as it relates to criminal justice. We've done really bold, innovative things around this area that have never been done before. And so the notion that somehow President Preckwinkle is using that authority for nefarious reasons is interesting, to say the least. Ms. Moore and I both presented our credentials. I got the endorsement from the Cook County Democratic Party several weeks ago. Ms. Moore presented her credentials back in August to Joe Barrios, to the rest of the party, as did Ms. Alvarez. The taint of the endorsement, because we brought it back up when we got the requisite votes, is now all of a sudden it's part of the partisan politics. I have, and I think the conversation and discourse with this office, and I will say it again, should be different than any other political office out there, because we are the gatekeepers of truth and justice. And allegations that are easily slung about based on hearsay and not verifiable, because, and it is you say with FOIA, Ms. Alvarez is terrible with FOIA, but it's out there that I ran for associate judge, and that we can get the application for associate judge that lists that information. It also will list how the bar associations rated me to be a judge back in 2011, which across the board I was rated qualified, and in 3 bar associations, 2 were highly qualified and 1 was highly recommended. And that's information, the fullness of that, when we say things to the public in an effort to be elected to the top law enforcement job in the county, in a county that doesn't trust its law enforcement, is really important. And so this defense of me is not just I think the conversation that we should be pushing, the questions we should be asking in this, when we talk about how the narrative is going about credentials, should be, is this how our state's attorney's office is gonna be run? Is this how we're gonna win cases? By picking and choosing facts and information based on a narrative that we want to tell.
Okay, well, we're gonna have to wrap things up. A very interesting conversation from both.
Thank
We appreciate you taking the time. We could easily go on.
Thank you. For our record, just, I read Laura Washington touching on this, but
Yes.
you said you've tried hundreds of felony cases, is that correct?
Right.
Okay.
Would they be bench trials?
Yes. It didn't say